afternoon.
Good afternoon, Your Honor.
Before we get started, can we just look around and do a quick conflicts check, see if you recognize anyone here? Good? All right, begin whenever.
We are here today to hear argument on the case of the estate of Clark Doig, if I'm pronouncing that correctly, versus Klein Wrestling Alliances. Can I get appearances, please?
Yes, Your Honor. Good afternoon, Your Honor. My name is Connor Yost, and I'm joined by my co-counsel.
Good afternoon, Your Honor. My name is Kristen Ballard.
And together, we represent the defendant in this case, the Klein Wrestling Alliance. Your Honor, we do have notices of appearance with the correct spelling of our names, as well as our team designation. May my co-counsel approach with copies for Your Honor, as well as the members of the jury.
Good afternoon, Your Honor. My name is Julia Lopez on behalf of the plaintiff.
Good afternoon, Your Honor. My name is Miguel Romero on behalf of the plaintiff. We have a number of preliminary matters we'd like to discuss with the court, as well as some substantive motions in limine whenever the court is ready. My co-counsel will be arguing the motion, Your Honor. I will cover some preliminary matters briefly. Yes, Your Honor. Pursuant to a pretrial meeting confer, we have agreed to pre-admit certain exhibits. Those exhibits being 1, 2, 6A, 8A, and 7. 1, 2, 6A, 8A, and 7.
No objection, Your Honor.
Additionally, Your Honor, we would like to ask if the court would like a formal tender for our extra witnesses in this case. Sure. That's all, Your Honor.
Yes. Your Honor, by way of background, Clark Doig died on August 6, 2022, as a result of performing a stunt on behalf of KWA. We believe that the defense will bring in evidence of Mr. Doig's prior stunts, and we move to exclude such evidence under 404 and 403. Under 404, this is improper character evidence, as we believe the defense is going to try to show that because Mr. Doig did stunts in the past safely, that he understood risks and assumed risks, and given that, he did the same on August 6, 2022. Further, under 403, this is substantially prejudicial as well as misleading the jury, as the jury will take that evidence and believe that because Clark has done safe stunts in the past, that he assumed the risk of the August 6 stunt. And the August 6 stunt was the first time Clark had ever done one like that before.
So what specifically are you seeking to exclude?
Any mention of Mr. Doig's prior stunts of jumping off 20-foot ladders or from 20 feet or 12 feet without a harness, as the August 6 stunt involves a 78-foot descent with a harness. It was the first time he ever did a stunt like that.
And it's your position that that's character evidence?
Yes, Your Honor, yes, it is.
What makes it character evidence?
His character for doing stunts safely. The jury will take that, or because he has done stunts safely in the past, it gives an inherent reason to believe that he assumed the risk and understood the risk, and in such, he did the same on August 6th. Yes, Your Honor.
Yes, Your Honor, we do. Yes, Your Honor. Your Honor, this evidence is not being used for propensity evidence, as in safe then, safe now. Rather, this evidence will be used to show that Mr. Doig had knowledge and notice of performing stunts as well as following safety instructions. Your Honor, in addressing opposing counsel's 403 argument, this is not unduly prejudicial, as this would be fundamentally misleading for the members of this jury to not know that Mr. Doig had prior experience performing stunts. For the members of the jury to believe this was his very first stunt from a height of 78 feet would be misleading.
Yes, Your Honor. The August 6th stunt was a different stunt. So any knowledge that Mr. Doig had on the prior stunts is completely different than any knowledge he may have had on August 6th.
Your Honor, may I briefly respond? Your Honor, this goes directly to Mr. Doig's assumption of the risk, the fact that he had knowledge as well as notice in performing stunts previously.
Would have denied the motion. Are there any other motions on that?
No, Your Honor.
Any other pre-trial matters addressed?
Yes, Your Honor.
Yes, Your Honor. We would like to put the court on notice that we are joined by a party representative here today, Cody Cotter. Additionally, Your Honor, we anticipate objections will be made throughout today's proceedings that would normally require us to approach the bench. May we ask...
Standing order that you can approach the bench without requesting.
Yes, Your Honor. And pursuant to the pretrial order in this case, we would just like to put the court on notice that Clark Doig's statements have been ruled as party opponent statements for today's proceedings to resolve any hearsay issues. Clark Doig, being the decedent in this case, being represented by the plaintiff.
I believe that was in the pre-trial order, was it?
Yes, Your Honor.
Would you like to respond?
We have no objection, Your Honor.
Okay, unless there are any other, right, you have the standing order to approach at any point in time, if we request it. We acknowledge that a party representative is sitting at the council table, and there is no issue with respect to the matters that were being addressed as it relates to a potential hearsay objection. Okay, with that being said, how do you wish to proceed?
Your Honor, we also have a few substantive motions that we were able to agree to with opposing counsel pre-trial that we would like to put on the record.
Pursuant to stipulation?
Yes, Your Honor.
How do you want to handle that?
I can just address them now.
Okay, please.
For the first motion, the parties have agreed to make no reference or mention to any changes in KWA's safety policies after this incident, as they are inadmissible subsequent remedial measures.
Yes, Your Honor, we reserve the right to object for impeachment purposes or if the door is open, but outside of that, we have no objection.
Next.
Your Honor, for the second motion, the parties have agreed to make no reference or mention to any statements or conduct by the defendant in this case, Klein Wrestling Alliance, that the fact that this wrestling match continued after Mr. Doig was taken to the ambulance via hospital.
Yes, Your Honor, same reasoning, impeachment purposes only.
And then for the third and final motion, the parties have agreed to make no reference or mention to a prior 2019 lawsuit wherein KWA was sued by a previous wrestler.
No objection, Your Honor.
With respect to all of those matters, should you wish to introduce evidence solely for the purpose of impeachment, that's fine. Are there any other preliminary matters that you need to bring to the attention of the court?
Yes, Your Honor. Given the exhibits have been pre-admitted here today, we ask permission to use Exhibit 6A and 8A in opening statements.
Response?
No objection, Your Honor, and I guess on our end as well, as they're pre-admitted, we are going to be using 1, 2, 6, 8, 8, 8 in our open as well.
I have no problem with using
Yes, Your Honor. Yes, Your Honor. And with that, we are ready to proceed to opening statements.
As his heart is pounding and sweat forming on his forehead, Clark Doig stands 78 feet above KWA Arena, awaiting to descend into the ring for a shot at a wrestling title. And as he's standing there thinking to himself, can I do this? He peeks over the catwalk, and the ground begins to look further and further away. Stomach drops. But one thing is ringing in the back of his mind. It's completely safe. The defendant told him earlier that day it's completely safe. And trusting in those words, Clark takes a step off the catwalk. But what he didn't know is that it wasn't completely safe. The defendant cut corners in preparing for this stunt. When Clark took that step off the catwalk, almost immediately, he was falling to his death. 4 cut corners and a dead man in the ring. Good afternoon. I'm Julia Lopez, and along with my co-counsel, Miguel Romero, we represent Bosai, Clark's brother. And we're here today because on August 6, 2022, Clark died while performing a stunt on behalf of the defendant. The defendant had an obligation to act as a reasonable wrestling company by protecting its wrestlers. I want to introduce you to Clark. This is Clark Doig. And I know what you're probably thinking to yourself. This guy, he doesn't look like a wrestler. He's kind of goofy looking. But that's the thing about this wrestling. It's an act. Because this is Clark away from the wrestler, away from the defendant. You also meet another Clark, Clark the Dragon Doig. This was his alter ego. See, without this, his skills weren't translating into popularity with the fans. He wasn't bringing in as much money as the defendant wanted. So Clark had to change who he was to this new character. But he wouldn't be a violent or menacing dragon. He'd be clumsy. It was his gimmick, his wrestling character. Now, the gimmick, that's an act. It's not real. But Clark suspended 78 feet in the air. The risks were real. The danger was real. And the consequences, they were deadly. The defendant stadium holds 1,100 people, and directly in the middle is the wrestling ring, and that's where the wrestling occurs. Now, 78 feet above that ring is a catwalk. And in this case, the defendant used the catwalk for stunts. And you'll hear that on August 6th, that wasn't the first time that the defendant had used this catwalk as a stunt. The first time was in 2021. And in 2021, the stunt was that a wrestler would descend from the catwalk into the ring. They'd perform and be put right back up to the catwalk. And that wrestler was secured by this locking carabiner. The defendant even hired a stunt coordinator, Sarah Williams, to oversee the stunt to make sure it was safe. She also provided the equipment. Now, this locking carabiner, it doesn't open easy. It takes 10 pounds of pressure to twist and 30 pounds to push in. That's how you open this. Now, in 2022, with Clark, stunt was a little different. Clark would still descend from the catwalk into the ring, but this time he'd release himself. And given this release, the defendant decided to use this. Now, the difference with this is that it's quick release. And you'll hear that the change from this to this, the defendant Googled it. He went online and typed, what kind of locks can I use for lowering a person? And it brought him this. What the results didn't return was a safety shackle, or a shackle safe for stunts, or hanging someone from the ceiling piece of hardware. It said, quick release sailing hardware. Clark was in a sailboat. And the risk of using this is that if you're anywhere but directly above the ground, with the quarter-inch movement, you're falling over 70 feet from a catwalk suspended above the ring, free falling to your death. Now, we have an expert that's going to speak to you today. His name is River Sukesh, and Mr. Sukesh is the Chief Stunt Safety Officer at Walt Disney Studios. And before that, he worked at Carnival Cruises and ABC Studios. Now, it's his first time testifying today. And when he speaks to you all, he's going to bring years and years of experience. Because unlike the defense's expert, it's his job to make sure stunts are done safely from the beginning. And when he speaks to you, he'll tell you that the defendant cut 4 corners. The snap shackle was not safe for the August 6th stunt. The defendant should have better explained the risks to Clark. Clark should have never been able to release himself during the stunt. And the defendant should have hired a stunt coordinator. And these 4 cut corners resulted in a dead man in the ring. That's why at the end of this trial, Mr. Romero will stand before you and ask that you find the defendant liable for the death of Clark Doig. Because those 4 cut corners resulted in a dead man in the ring.
Yes, Your Honor. Can I grab the exhibits real quick?
Yeah, of course.
Thank you. May I proceed? They were in it together. Members of the jury, we agree. This was a risky stunt, and at no point today will we try to tell you that it wasn't. But when the plaintiff was up here moments ago, they made it seem like KWA was the only one that knew that this stunt was risky. But the evidence will show that Clark Doig, he knew it too. KWA and Mr. Doig were a team. They were in it together. You'll learn today that together they looked at this shackle. And together they talked about pulling this rope to open it. And together they practiced with this shackle and this rope 4 times. And together they knew that this shackle was easier to open. They were in it together. Members of the jury, what happened to Mr. Doig is tragic. But today, the plaintiff has the burden to prove that his death was KWA's fault. And we understand. KWA has some responsibility here. But they didn't do this stunt alone. And that's why we have raised the affirmative defense called assumption of the risk, which means that we have a burden here today too. We must prove that it's more likely than not that Clark Doig knew about and assumed the risk of this stunt. And we'll meet that burden here today by proving 2 things. That together, KWA and Mr. Doig planned and practiced. But before we talk about how they planned and practiced, let's take a step back and talk about KWA and entertainment wrestling. KWA is a small, professional wrestling company located right here in Philly. And the wrestlers, they take on character roles. Think of it this way. In the WWE, we have The Rock and The Undertaker. The same could be said about KWA. And these wrestlers take on those character roles, step into the ring, and begin physically fighting their opponent while the fans cheer them on. It's a violent, aggressive, and even a dangerous business. We don't deny or dispute any of that. But you'll learn today that Clark Doig, he knew that better than most. He was KWA's oldest, most experienced, high-flying wrestler, which means that he knew how to jump off 12-foot ladders and 16-foot cages and then land precisely so he wouldn't hurt himself or someone else. Now, when the plaintiff was up here moments ago, they implied that KWA forced or pressured Mr. Doig into this stunt. But the evidence will not support that claim. You'll learn today that KWA and Mr. Doig were a team. And KWA had pitched Mr. Doig multiple character ideas, but Mr. Doig turned those ideas down. And they continued to work together to find the right fit. And in June of 2022, just a few months before this tragic incident, Mr. Doig became Clark the Dragon Doig. And the dragon took off. The fans loved it, and they embraced it. And that's what led KWA and Mr. Doig coming up with that plan that I mentioned earlier. A plan to create even more fan excitement around the growing success of the dragon. A plan for the dragon to do an exciting stunt at a big live event where the dragon would descend from the ceiling down to the ring with his arms stretched out to his sides. Then he'd quickly release himself, drop into the ring, and begin fighting his opponent. Now, initially, the plan was for Mr. Doig to be attached to this locked carabiner. But you'll learn today that when they first started practicing, Mr. Doig struggled. He struggled to release himself from this carabiner. And what the plaintiff didn't mention moments ago is that Mr. Doig actually complained about the speed of the release. You'll learn today that Mr. Doig said, "It feels so lame, just dangling here, trying to unlock this thing." Members of the jury, this brings us to the shackle. And something that the plaintiff didn't just mention moments ago is that when the owner first got the shackle, they didn't just slap it on Mr. Doig and say good luck. No. The owner showed Mr. Doig the shackle, told him it would solve the release issue, told him that it was safe, and told him not to move his body, especially his arms, because it could cause the shackle to release. Together, they agreed to use the shackle. Together, they agreed to trust in Mr. Doig's experience as a precision and technical wrestler. This is what brings us to how KWA and Mr. Doig practiced. That's right, they practiced. They practiced with that shackle together 4 times. And pay close attention to what Mr. Doig said after those practice runs. Another thing that the plaintiff didn't tell you moments ago. You'll learn that Mr. Doig said, "Wow, it's so much easier to use this shackle than the other one." And not only that, you'll learn today that Mr. Doig was reminded again not to move his body, especially his arms, because it could cause the shackle to release. Members of the jury, we won't hear any evidence today that Mr. Doig didn't want to do this stunt or that he didn't agree to do this stunt. In fact, you'll hear the exact opposite today. You'll learn that Mr. Doig wanted this stunt to be successful. And just moments before the stunt occurred, you'll learn that Mr. Doig said, "It's time for the dragon to fly." They were in it together. And that's why, at the end of this trial, my co-counsel, Ms. Ballard, will come before you and ask you to return the only verdict consistent with the facts, the law, and your own common sense. A verdict that, yes, we agree, acknowledges KWA's part in this, but also a verdict that acknowledges that Clark Doig assumed the risk of this stunt because they were in it together. Thank you.
Yes, Your Honor. The plaintiff calls Sid Gaskin. Good afternoon, Ms. Gaskin. Good afternoon. Please introduce yourself to the jury.
Hi, my name is Sid Gaskins.
What do you do for a living?
Currently, I'm unemployed, but before I was working for KWA as a booker and a ring announcer.
What is KWA?
KWA is the Klein Wrestling Fusion. It's a small local wrestling company.
How'd you get into wrestling?
I was a wrestler myself for 11, 12 years. And then once I decided to get out of wrestling myself, I got a job with KWA as an announcer.
You mentioned you were a booker. What does that mean?
A booker is a person that writes the storylines, books the shows, schedules the performers, all of that kind of stuff.
When you say books the shows, what does that entail?
Well, it entails a lot of things, from writing the storylines for characters to making sure that the wrestlers show up and that they perform a really good
You said you wrote the storylines. Can you elaborate?
Wrestling is mostly real, but a little bit of it is fake. So a lot of our wrestlers have storylines and characters where they fight each other and have revenge stories and all sorts of stuff.
What parts of wrestling are real?
The stunts are real. We have our wrestlers actually in the ring and throwing stuff at each other and stuff like that.
I want to get into why we're here today. Did you know a person named Clark Doig?
Yes, I did.
Who was Clark?
He was a good friend of mine and one of our wrestlers at KWA.
Would you recognize a photo if I showed you one?
Yes, I would.
Your Honor, permission to approach the witness? Ms. Gaskin, what did I just show you?
This is a picture of Clark Doig.
Permission to publish for the jury, Your Honor?
No objection, Your Honor.
It's been pre-admitted, Your Honor. How would you describe Clark's role in KWA?
He was one of our most experienced wrestlers, but he wasn't over with the crowd, so he got booked in the middle of the show a lot.
You used the word over. What does that word mean?
Over means popular with the fans. Either they love them or they hate them, but they're at least engaged.
How does a wrestler become over?
Well, we use what we call gimmicks to help the fans like and get to know a wrestler.
Have KWA ever suggested some of these gimmicks or some of the storylines you were mentioning to Clark?
Yeah, we ran a lot of gimmicks past Clark before, but he wasn't a big fan of a lot of them.
How would he respond?
You know, he didn't want his kids to hear his bad storylines and stuff like that, so he usually rejected them.
Did he ever develop a gimmick?
He did. He created Clark the Dragon Doig.
When you say we, who do you mean?
Well, it was Cody Cotter's idea primarily, but we pitched it to Doig in June.
Were you there when it was pitched?
Yes, I was there when it was pitched.
What was Mr. Doig's reaction?
He didn't love it, neither did I, but eventually I think he got on board.
During that conversation, did Cody Cotter mention anything?
Yeah, Cotter said that Clark needs to give it a chance or else his future with the company might be limited.
May the record reflect that I have in my hand what is already in evidence as Exhibit 2. Permission to approach the witness, Your Honor?
Standing order that you can approach without violence.
Yes, Your Honor. Thank you, Your Honor. Ms. Gaskin, what did I just hand you?
This is a picture of Clark Doig dressed up as Clark the Dragon.
Permission to approach the jury, Your Honor?
Yes.
How many matches did Clark use the dragon gimmick in?
He used this gimmick in 3 of his matches.
What was the gimmick?
Well, he was basically a silly dragon.
You mentioned that he used it in 3 matches. Was there any plans to continue the gimmick?
Yes, there was a 4th event planned for Saturday, August 6th.
What was the plan?
Well, the plan for that show, since it was a bigger show, was to have him kind of fly in from the catwalk down to the mat and then have him drop and fumble a little bit once he got closer.
And what happened on August 6th?
Well, the stunt went wrong that day, and that's unfortunately the day that he died.
During your time at KWA, had they ever done a similar stunt?
Yes, they had done a similar stunt back in June of 2021, I believe.
Were you involved with that stunt?
Yes, I was.
How did the defendant prepare for that stunt?
Well, they hired a stunt coordinator. I think her name was Sarah Williams. And she came and organized the whole thing, brought equipment, everything like that.
What about for the 2022 stunt? Were you involved with the preparation for that?
Yes, I was.
How did the preparation go?
Well, it was different from 2021. We didn't hire a stunt coordinator, and we just reused the same equipment.
Did you come to learn why a stunt coordinator wasn't hired?
Yeah, Cotter said that the money wasn't worth it.
Did you practice at all for the August 6th stunt?
Yes, there were a total of 8 practices.
When were the practices?
Well, there were 4 on the Tuesday before the event and 4 on the afternoon of the event.
Were you there for those practices?
Yes, I was there.
Let's start by talking about the Tuesday practice. How did those go?
They were okay. You know, Doig kept kind of fidgeting with his cape and around his neck and wrists, and then he had some trouble releasing himself once he got close to the mat.
What was the response to him having that trouble?
Well, on the next day of practices, on Saturday, that's when Cotter showed up with the snap shackle to replace the locking carabiner.
How did those practices go?
They were okay. Doig kept fidgeting in the same way, and during 2 of the dives, he started fluttering his arms a little bit.
What happened when he fluttered his arms?
Well, Cotter freaked out and gave Doig a lecture about how it was unsafe for him to do that.
I want to talk about where you were when Clark was going to be doing this entrance. Where were you?
I was down by the ring.
What could you see from there?
I could see, you know, the entirety of the ring and the mat, and up until about 20 feet underneath the catwalk.
When did you first see Clark?
I didn't see him until after he passed that 20-foot mark. He was falling.
What happened after you saw him falling?
He yelled. I think he said, "Watch out," and then he hit the mat.
No further questions.
Cross? Yes, Your Honor.
May I inquire?
Beg your pardon?
May I inquire?
Certainly.
Thank you, Your Honor. Good afternoon, Ms. Gaskins.
Good afternoon.
Let's start with Clark Doig's experience. He was KWA's most senior wrestler,
Yes, he was.
their most experienced wrestler.
Yeah, he had been doing it for a long time.
And this wasn't his first time doing a stunt in the air, correct?
Objection, Your Honor. We would like to renew our 404 argument from motion and eliminate in order to preserve our record.
Your objection is denied. Please proceed.
Ms. Gaskins, I'll repeat that question. This wasn't Mr. Doig's first time doing a stunt in the air, correct?
It wasn't his first time doing a stunt.
Right, he had jumped off 12-foot ladders.
Yeah, but this jump was 78 feet.
Right, and he had also jumped off 16-foot cages.
Yeah, once or twice, I think.
He was an excellent technical wrestler.
Yeah,
He was able to control his body,
from what I could see,
and he'd land safely,
yeah, he was a good wrestler.
and he wouldn't hurt himself.
I'd like to think no.
Let's talk about the stunt in this case. Cody Cotter pitched the stunt to Mr. Doig,
Yes, he did.
and Mr. Doig agreed to do the stunt.
He did.
And just to clear something up that you mentioned on direct, KWA had pitched, Mr. Doig, multiple character ideas in the past, correct?
Yes, we had pitched him repeatedly, but this was the first one that he stuck.
Right, and Mr. Doig had turned those other ideas down.
Yes.
And when he did, KWA didn't pressure him into those character ideas
The previous ones, no.
or force him into those character ideas.
No.
Let's talk about this stunt. You mentioned the plan, let's talk about this stunt here. You heard Mr. Doig say that he thought that this stunt would get the dragon over.
Yeah, that's what we all thought.
And as you mentioned moments ago on direct, over in the wrestling industry means to become popular with the fans, correct?
Yes, that's what it means.
Let's talk about the plan for this stunt. The plan was for Mr. Doig to go down with his arms to his sides,
Yes.
meaning he wasn't supposed to flap his arms.
No, he wasn't.
Let's talk about how that plan was practiced. Cody Cotter and Mr. Doig practiced this stunt
Yes, we all did.
together
Yes.
on 2 separate days.
Yes.
And as you mentioned moments ago, you were there for both of those practice days.
Yes, I was there for all 8 attempts.
And in all those 8 attempts, you saw the equipment that was used.
Yes, I did.
Let's talk about the first practice day. This was 4 days before the event.
Yes, on Tuesday.
And they practiced with this carabiner.
Yes, they did.
meaning that Mr. Doig agreed to descend from the ceiling,
Yes.
attached to this carabiner,
Yes, there was a second one too.
right, and he would release this carabiner by reaching behind his back.
Yes, he'd have to untwist it and then push it in.
But he struggled to release himself.
Yeah, he did.
In fact, you heard Mr. Doig say, "It feels so lame."
Yeah, it was a struggle to try to unclip behind your back.
Right, he said he felt so lame just dangling here,
Yeah,
trying to unlock this thing.
like I said, yeah.
Let's move to the second practice day. This was the same day as the event.
Yes, the afternoon of.
And Cody Cotter brought this shackle to practice.
Yes, 4 hours before the show.
And he brought the rope that was attached to it as well.
Yes, he did.
And Cody Cotter showed Mr. Doig the shackle and the rope.
Yes, she did.
And together, they practiced with this shackle,
Yes, for 4 jumps.
meaning that Mr. Doig agreed to descend from the ceiling,
Yes,
attached to this shackle,
yes.
and pull this rope to release himself.
I mean, he did it.
And after he did it, you heard Mr. Doig say, "Wow, it's so much easier to use this shackle than the other one."
Yeah, it was a lot easier to release.
And they practiced with this shackle 4 times.
Yes, on the day of.
Let's talk about those 4 practice runs. During those 4 practice runs, Mr. Doig, he didn't stick to the plan.
I don't think that's true.
Ms. Gaskins, you saw Mr. Doig flap his arms on the way down?
Yeah, it seems like a panicked kind of motion.
Ms. Gaskins, you saw him flap his arms like this.
Yes,
And when he did that, he was met with a warning,
yes, he was.
meaning that Cody Cotter came down from the ceiling.
Yes, she came down and she yelled at him.
Right, she yelled, "Don't do that thing with your arms."
Yeah, because it was unsafe.
Right. Cody Cotter said, "It's not safe."
Like I said,
And after that warning was given, 2 more practice runs were conducted.
yes,
And in those 2 practice runs, Mr. Doig, he stuck to the plan.
he seemed scared and stiff, but yeah.
Ms. Gaskins, to be clear, Mr. Doig didn't flap his arms on the way down.
No, he didn't.
Let's move to those few practice runs were done a few hours before the show, correct?
Yes,
Let's talk about that time between those practice runs and the stunt later that night. During those hours, you never heard Mr. Doig raise any concern about this stunt?
no, I was running around doing other things.
You never heard him raise any reservation about this stunt?
No,
And you mentioned that you were running around doing other things, but you did go check on Mr. Doig.
I did.
And when you went to go check on Mr. Doig, you never told Mr. Doig to not do this stunt?
No, that wasn't my position to say.
But it was your position to make sure that he was ready for the stunt.
It was my position to make sure that everyone was ready for the show.
In fact, you asked your very good friend, Mr. Doig, "Are you sure you want to do this?"
I did.
And in response, Mr. Doig laughed.
Yeah,
He laughed and said, "It's time for the dragon to fly."
yeah, he had bought into the gimmick.
Moment to confer, Your Honor?
With counsel?
Yes, Your Honor.
Sir.
No further questions, Your Honor.
Okay. I'm not familiar with the rules we're using. Is redirect permitted? Yes. Do you have redirect? Yes, sir. Okay.
Ms. Gaskin, at any point, did you hear anyone mention to Mr. Doig that the snap shackle was meant for sailboats?
No, I don't think so.
At any point, did you hear someone tell Mr. Doig that a stunt coordinator had not been consulted?
No.
When you talked to Clark Doig backstage on August 6th, what was his demeanor like?
He seemed nervous.
Any recross? No, Your Honor. Okay. Step down, please.
Thank you, Your Honor.
Your Honor, before calling our next witness, may I read a stipulation onto the record?
Certainly.
Stipulation 2. On August 6th, 2022, the 20 feet directly beneath the catwalk was not visible to the audience, which meant that Clark Doig was not visible to the audience until he was 58 feet above
Counsel, I assume that you've stipulated to this?
Yes, Your Honor.
Okay. You're to consider that stipulation like any other evidence that might be admitted in this case.
Your Honor, one more stipulation.
Certainly.
Stipulation 4. Clark Doig was 177 pounds on the day of this thing.
Again, that stipulation has been agreed to prior to the hearing?
Yes, Your Honor.
Okay, again, that should be considered like any other evidence that's been presented. With those stipulations read to the jury, are there other witnesses that you intend to call?
Yes, Your Honor. We call Rivers Sukesh to the stand.
Yes.
Mr. Sukesh, do you agree that your testimony will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor, I do.
Okay. Please proceed.
Good afternoon. Introduce yourself to the jury.
Sure. Hi, everyone. My name is Rivers Sukesh.
Mr. Sukesh, what do you do for work?
I'm the Chief Stunt Safety Officer at Walt Disney Studios.
And what's your involvement in today's case?
I was hired by the plaintiff in this case and asked to review the evidence and information provided to reach an opinion on whether KWA, the defendant wrestling company, acted safely in reasonably conducting their stunt on August 6th.
Now, before we get into your opinions, I want to discuss your qualifications. So tell the jury your educational background.
Sure. I have a BS in mechanical engineering from Fordham. I also have a minor in theater.
And other than your formal education, do you have any certifications?
I do. I'm a certified stunt professional. I'm also certified in wire work and rigging and work at heights safety. I've had those certifications for years.
And what other work experience do you have that's relevant to why you're here today?
Before I started at Walt Disney Studios, I was actually at ABC Studios for about 10 years. I spent 6 years as a stunt rigging assistant, and once they trusted me, they let me be the stunt coordinator for 4 years. I also started my career on Carnival Cruises. I was in charge of making sure that the live performances on the cruises were conducted safely.
Have you ever testified before?
Actually, no, ma'am. This is my first time.
How many stunts have you worked on in your career?
I don't know that I can give you an exact number. I know it's well over 100. I do know that 25 of the stunts have involved descents of more than 40 feet.
Do you adhere to industry standards within your profession?
Absolutely. I'm part of several professional organizations, and in those, we adhere to standards set by the industry somewhat formally. With the certifications that I have, there's typically an educational component that requires knowledge on the rules of stunt safety.
Do you have any awards or certifications that are relevant to why you're here today?
I have a couple awards. I have the Taurus World Stunt Award for the best specialty stunt in TV. I also have the SAG Award for the best stunt ensemble in a short film.
Are you published?
Yes, ma'am. Two of my publications that come to mind are my work on the importance of hiring stunt professionals and also my work on how to jump safely without a harness.
Now, you mentioned that you were hired to form an opinion regarding the August 6th stunt. Did you, in fact, form an opinion?
Yes, ma'am. There are about 4 components to my opinion.
And how did you come to form these 4 components to your opinion?
Well, with all of my work, I bring all of my education, experience, and training. In this case, I was lucky enough to do a site visit and inspection of the equipment within 2 weeks of the incident. So I went to KWA Arena, I inspected the catwalk, the ring, the ceiling, and tested all of the equipment that was used. I was also provided with other materials, such as depositions of the 2 main witnesses, and several exhibits, photographs, things like that.
Do you hold your opinions to a reasonable degree of professional certainty?
Absolutely.
Your Honor, at this time, plaintiff offers Rivers Sukesh as a professional stunt expert with an emphasis in wire work, height safety, and mechanical engineering. In particular, Mr. Sukesh will offer an opinion regarding the height, performance, and safety of the August 6th stunt.
Counsel, would you like to question the witness with respect to this proffer that he will be testifying as an expert?
No, Your Honor, we have no objection.
Okay, you may proceed.
Mr. Sukesh, what was your conclusion of the August 6th stunt?
Well, in regards to the August 6th stunt, it's my opinion that KWA cut some corners. There are 4 areas I've identified. First, they should not have used a snap shackle and should have instead used a locking carabiner. Second, they should have better warned Mr. Doig about the risks of using that snap shackle. Third, he shouldn't have been able to release himself for this stunt. And fourth, KWA should have hired a stunt coordinator.
I have in my hand Exhibits 6A and 8A. I'm going to hand this to the witness.
Thank you.
Mr. Sukesh, you just said that you had 4 components to your ultimate conclusion, and I want to take those one by one. So, starting with the first, why was the snap shackle unsafe for the August 6th stunt?
Sorry for the noise a moment ago. There are a few reasons why this snap shackle was unsafe. I'll start with the fact that it wasn't designed for the stunt on August 6th. It's actually a piece of sailing hardware.
Well, what's wrong with using that for something other than its intended design?
Well, it's not always wrong to use equipment for other purposes. In fact, it's fairly common in the stunt industry to use equipment designed for other purposes. But to do that, you have to make sure the equipment is safe for the particular stunt. In this case, it wasn't. We're talking about a descent of over 70 feet here. And the thing about these snap shackles is that they're designed to be opened quickly and easily, only taking a 1/4-inch pull with 9 pounds of pull pressure on the ring here, and the ring opens.
Mr. Sukesh, how much weight could that snap shackle hold?
This one could hold up to 975 pounds.
We know that Clark didn't weigh 975 pounds, so what was the issue?
It's not about whether or not this could hold Mr. Doig. It certainly could. The issue is the fact that it can be opened so quickly and easily, making an inadvertent opening possible, likely even.
In your opinion, what equipment should have been used for the August 6th stunt?
The thing about the August 6th stunt is that there are no laws, guidelines, or regulations, but there are certainly industry standards. And the industry standard equipment for a descent of more than 15 feet is to use locking carabiner. In this case, KWA should have used 2 of these.
Now, before we go further, you mentioned industry standards. Explain to the jury what an industry standard is.
Of course. You can think of an industry standard like the criteria or the commonly accepted practice set in a particular industry. That's why we call it an industry standard.
Why are they important to follow?
Well, there's a reason that so many people in a particular industry agree and accept particular pieces of equipment for particular stunts. They're safe.
You mentioned earlier that the defendant should have used 2 locking carabiners for the August 6th stunt. Show the jury what you mean by that.
Sure. You'll notice with these locking carabiners, they don't open with a pull or even a strong push. You first have to twist with 10 pounds of pressure and then push in with 30 pounds of pressure. That's the only way to get it to open. In this case, they should have used 2 of these interlocked together, one connected to Mr. Doig's harness and the other to the rappelling rope.
How many locking carabiners were used for the August 6th stunt?
The August 6th stunt involved 1 locking carabiner. The second, or what should have been the second locking carabiner, was replaced with the snap shackle. So all it took for Mr. Doig to be released was this 1/4-inch pull.
Now, moving to your second opinion, you mentioned that the defendant should have better explained the risks to Clark. What do you mean by that?
Yes, ma'am. Given the risk of an easy, inadvertent opening with this snap shackle, KWA should have made it abundantly clear what Mr. Doig was getting himself into, like how this could accidentally open, even if he didn't want it to.
Are you suggesting that they never said anything at all?
Well, no. There were some instructions given to Mr. Doig, but they weren't enough. Mr. Doig wasn't able to comprehend really the risk of an inadvertent opening
Objection,
here.
speculation.
Yeah, I don't know how an expert would know what was said to Mr. Doig under these circumstances, unless you can establish some basis as to what was and what wasn't said to the plaintiff. I think the objection is well rooted.
Your Honor, may I be heard?
Yes, please.
We laid in foundation that this witness has actually reviewed the testimony of both Cody Cotter and Sid Gaskins, and therefore he is explaining what was said to Clark.
So you're relying upon the deposition testimony taken to enable him to provide an expert opinion as to what was said and what wasn't said. I'm going to allow you to examine him with regard to what should have been said. I don't think it's appropriate for you to adduce testimony with regard to what was and what wasn't said.
Okay, Your Honor. Mr. Zukish, in your opinion, what should the defendant have said to Clark regarding the risks of the stunt?
KWA should have made it very clear that Mr. Doig could inadvertently open this snap shackle, even if he didn't want to open it.
Is there any contention that the snap shackle inadvertently opened?
It seems that in this case, the snap shackle did inadvertently open. That's exactly the problem. That's why it first shouldn't have been used in the first place, and second, why KWA should have better warned Mr. Doig.
Turning to your third opinion, why should Clark not have been able to release himself during the August 6th stunt?
When you're doing stunts, the performer is focused on many other things.
Objection, speculation.
Overruled.
Namely, the performer is thinking about the stunt that they're executing. They're thinking about their lines of dialogue that they may have, any stage cues. With so much on their mind, it makes an inadvertent opening of a piece of equipment like this much more likely, as what happened on August 6th.
And turning to your fourth and final opinion, why should the defendant have hired a stunt coordinator for the August 6th stunt?
The purpose of a stunt coordinator is to explain what you can and cannot do when it comes to stunts, what you should and should not do. A stunt coordinator very well would have explained to KWA that their plans for the August 6th stunt were unsafe and that they should have changed some of their plans.
And given your training and experience, had the defendant called you prior to the August 6th stunt regarding their plans, what would you have instructed them to do?
I first would have instructed KWA that their plans for the August 6th stunt were unsafe, that they should use the industry standard locking carabiner for their setup. If they insisted on using the snap shackle, I would have instructed them that they should better warn Mr. Doig about the risks involved and that he shouldn't have been able to release himself.
Nothing further, Your Honor.
Ms. Bauer, will you be cross-examining the expert?
Yes, Your Honor. However, prior to proceeding, may I retrieve the exhibits from the witness?
By all means.
Here you go.
Thank you. Oh, my goodness. Thank you, Mr. Yost. May I proceed?
Certainly, please.
Mr. Sukesh, you were able to visit the KW Arena,
Yes, ma'am.
and you were able to inspect all of the equipment used in this stunt.
Yes.
You found that those steel cables, they weren't broken.
No, almost all of the equipment was intact. I think all of it.
Yeah, in fact, none of the equipment you inspected that day was damaged in any way.
That's right.
After that inspection, you determined Ms. Cotter didn't drop Mr. Doig.
That's right. Ms. Cotter did not drop Mr. Doig.
And let's be clear for the members of this jury, other than that shackle, KWA owned all of this equipment already.
Yes.
From a prior stunt
Yes.
in 2021,
Yes, ma'am.
when Mr. Doig was working for KWA.
My understanding is that he was working KWA at the time.
You're also aware that in that stunt, the carabiner was used.
The locking carabiner?
Yes, the locking carabiner,
Yes, ma'am, it was.
the industry standard carabiner.
Yes.
Well, let's talk about why that was used in 2021, but not in this stunt. You've reviewed the entire record in this case.
Yes, ma'am.
So, Mr. Sukesh, you're aware this stunt started with Mr. Doig using that industry standard carabiner.
Yes, that's right.
You're also aware Mr. Doig complained.
Yes.
He said, "It feels so lame,
Yes.
just dangling here, trying to unlock this thing."
Yes. It appears Mr. Doig had some frustration with the locking carabiner setup.
And those were his words.
Yes.
Cody Cotter bought a shackle.
Yes, it was Miss Cotter who bought the shackle.
But she didn't just slap it onto Mr. Doig's vest and say good luck.
No, of course not.
Of course not. She tested it
She tested it with a bag of sand.
4 times with a bag of sand.
4 times with a bag of sand?
Yes.
I don't believe that's correct.
You've reviewed this entire record.
Yes.
You're aware that this was practiced 4 times.
This stunt was practiced 4 times with Mr. Doig.
4 times with the bag of sand first.
I don't believe that's correct.
Okay, Mr. Sukesh, we'll move on. But we can agree this was practiced with the bag of sand.
Yes.
That weighed even more than Mr. Doig.
The bag of sand was 250 pounds?
And Mr. Doig, he was 177 pounds.
Yes, ma'am.
The weight wasn't an issue.
No, I discussed that earlier.
And in those practice runs, there were no issues with the shackle.
Which practice runs? Are you referring to the...
With the sandbag, there were no issues with the shackle.
No, ma'am.
And then Mr. Doig arrived to the arena.
Yes.
And Miss Cotter, she showed Mr. Doig the shackle.
Yes, ma'am.
In fact, you're aware that she offered to put on the vest.
She did.
She offered to go up 78 feet in the air,
Yes.
release herself into the ring,
Yes.
and show Mr. Doig how that shackle worked.
Yes, ma'am.
But that didn't happen.
No.
Mr. Doig, he wanted to practice himself.
Yes, Mr. Doig began practicing immediately.
Well, I want to focus on something you touched on in direct. You said that KWA didn't give adequate warnings. That's a yes?
Yes, ma'am.
But you're aware that before Mr. Doig could ever put his hands on that shackle, he was told to be still.
Yes, ma'am.
And then they practiced the stunt together.
Yes, Miss Cotter lowered Mr. Doig.
Miss Cotter in charge of the ropes,
That's right.
Mr. Doig rappelling down into the ring.
Yes, ma'am.
And on that first practice run, Mr. Doig stuck to the plan.
That's my understanding.
Well, he didn't flap his arms.
That's right.
The pin didn't release early.
That is also right. The practices, the pin didn't open.
Well, in that second practice run, though, something was different.
Are you referring to the fact that Mr. Doig began to move?
Mr. Doig began to flap his arms.
Yes, ma'am.
Miss Cotter ran down to the ring.
Yes.
You're aware that she yelled at him.
Yes, ma'am.
She told him, don't do that thing with your arms.
That's what she said?
She said it's not safe.
Yes, ma'am.
She told him it's a matter of life and death.
She did.
That was the second warning he received that day.
Yes.
And then they practiced again for a third time.
Yes, ma'am.
Mr. Doig stuck to the plan.
Yes, I believe Mr. Doig did not move his arms for the final 2 practices.
You believe or you know he didn't move his arms.
I know, ma'am.
And the pin didn't release early.
Yes.
Because just as you testified on direct, any inadvertent movement could cause that pin to pull.
That's right.
And this pin, it was taped to Mr. Doig's vest.
Yes.
After that 4th practice run, Mr. Doig said something about that shackle.
Yes, he did.
He said, wow, this shackle is so much easier to open than the other one.
He did.
And then they were done practicing for the day.
Yes, that's right.
He went to get something to eat.
Yes, after the 4 practices, Mr. Doig left.
And the Brotherly Slam was later that evening.
Yes.
And this was one stunt
This was one stunt for August 6th, yes.
in the middle of the entire event.
Yes, my understanding is that Mr. Doig was mid-card, so I believe he was round 4.
He was mid-card, so he wasn't headlining the stunt or the event.
No, ma'am.
Ms. Cotter was in charge of the ropes that evening.
That's true.
You're aware from your review of the record that she lowered him down.
Yes.
She was lowering him about 10 feet. She saw 1 or 2 quick movements.
That's what she accounts.
That's when she saw Mr. Doig fall.
Yes, according to Ms. Cotter's account.
A moment to confer.
Yeah.
No further questions.
Would you like to ask any more questions of the expert witness that you've?
No, Your Honor. May this witness be excused?
Yes, certainly. Yes, please step down.
Thank you, Judge.
Any more witnesses from the plaintiff?
No, Your Honor. At this time, plaintiff rests.
Plaintiff rests. Defense, are you ready?
Your Honor, at this time, the defense has one motion to be heard outside the presence of the jury.
Okay, please excuse yourself, jury, metaphorically.
Your Honor, at this time, the defense moves for a judgment as a matter of law pursuant to Federal Rule of Civil Procedure 50A. When viewing the evidence in the light most favorable to the non-moving party, the plaintiff has failed to put forth sufficient evidence from which a reasonable jury could find that they have met their burden. In looking at the negligence claim, all of the evidence and testimony presented today shows that KWA and Clark Doig were in this together. That together they agreed to do the dragon stunt. Together they agreed to use the quick release shackle rather than the carabiner. Together they agreed Mr. Doig would release himself. And they agreed that he would perform this stunt at the Brotherly Slam. For these reasons, no reasonable jury could find that the plaintiff has put forth sufficient evidence, and we ask Your Honor to grant the motion.
Would you like to be heard?
Yes, Your Honor. We would oppose this motion. We have presented evidence that KWA acted unreasonably, and through their negligence, by them cutting four corners in this situation, it led to a situation where Clark Doig was put in danger and died as a result. There is evidence put forward that the Snapchat should not have been used for the stunt, that a stunt coordinator should have been contacted, that instruction should have been better, and that Clark Doig should not have been able to release themselves. A jury could reasonably find that the defendant was negligent in this case.
I'm going to deny the Rule 50 motion. Defense, are you ready to proceed?
Your Honor, could we have a brief 5-minute recess prior to proceeding?
Certainly. How are we doing time-wise? Thank you. What schools are we seeing today? What schools? Am I allowed to know that? Okay. I have those. I wrote those down. The plaintiff is 107 and the defense is 101. And this is considered round one, is it not? This is round two. And what happens after today? Same case, obviously. Okay, I said the plaintiff was 107, the defense was 101? Yeah. Are there faculty advisors that travel with the teams? Are there faculty advisors that travel with the teams? Coaches? And these are not post-law school advocacy, litigation degrees. These are three-year students? Okay. Current law students, right. Because there are some schools that provide post-degree tax degrees or litigation degree, right? Temple being one of them, yeah. Right. Are you ready?
Yes, Your Honor.
Plaintiff? Yes, Your Honor. Okay, please call your first witness.
Your Honor, at this time, the defense calls Cal Sism.
Well, I'm going to administer an oath. Do you agree that your testimony will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor, I do.
Can you state and spell your name for the record?
My name is Cal Sism, C-A-L-S-I-S-S-O-M.
Okay, please proceed.
Good afternoon, Ms. Sism. Can you introduce yourself to the members of the jury?
Good afternoon. My name is Cal Sism.
Ms. Sism, how are you involved in today's case?
I was hired by the defense to analyze and come to an opinion regarding the safety equipment used in the stunt surrounding Clark Doig's death.
Ms. Sism, before we get to that opinion, I want the members of the jury to get to know you. What do you do for a living?
I am the owner and principal founder of Safe Performance Solutions.
What does Safe Performance Solutions do?
We provide safety solutions and advice to those involved in the dangerous sport of stunt and wrestling entertainment.
Well, Ms. Sism, what kind of degree do you need to get into that line of work?
Well, I have a bachelor's degree as well as a master's in occupational safety and health.
After you graduated with those degrees, what did you do?
I began working in the stunt industry first, so I was a senior stunt coordinator with Warner Brothers Studios before I transitioned into the wrestling industry.
What did that transition into the wrestling industry look like for you?
I first started working for the World Wrestling Entertainment, or the WWE for short, which is basically just the Premier League of wrestling. It's what you think of when you think of those big televised events.
What kind of work were you doing for the WWE?
I was the senior stunt coordinator as well as a safety consultant for them. Basically, I was the girl you would come to if you wanted to do something risky, but make it safe.
How long did you do that for?
I worked with the WWE for about 8 years before I decided to go off and do independent work.
Do you hold any special licenses or certifications?
Yes, I am a certified safety professional.
Are you a member of any professional groups or organizations?
Yes, I am a member as well as a former vice president of the American Society for Safety Professionals, and I'm also a member of the Wrestling Professionals Association.
Have you ever worked as a professional consultant?
I have, yes.
How often?
Over 60 times.
Have you ever testified as an expert witness in stunt safety?
I have, yes.
How many times?
4 times.
And generally, when you're testifying, who is it you're testifying on behalf of?
It is usually on behalf of the wrestling companies or wrestling industry.
Ms. Sism, are you being paid for your work in this matter?
Yes, to date, I've been paid $31,000 for my time in coming to my opinion, as well as making an additional $1,000 an hour for my time testifying at court.
Well, before your time testifying in court, were you able to review any documents or materials?
Yes, I was.
What did you review?
I reviewed all of the exhibits contained in the record, as well as Mr. Sukesh's expert report, and also conducted an independent site inspection of the equipment used in Clark Doig's stunt.
Are those the kinds of things that experts in your field rely on when forming an opinion?
Yes, they are.
Ms. Sism, in your industry, are there any sort of policies or standards that you're required to uphold yourself to?
Yes,
Did you apply those in forming your opinions in this case?
absolutely, yes.
Do you hold your opinions within a reasonable degree of professional certainty?
I do.
Your Honor, at this time, the defense offers Cal Sism as an expert in stunt safety.
Plaintiffs? Certainly. Please proceed.
Mrs. You're not a mechanical engineer.
No, I am not.
You don't have any engineering degree.
No,
You don't have any certifications on the mechanics of stunt equipment.
not the mechanics of it, no.
You don't have any specialized knowledge
Not the design of equipment, no.
You don't have any specialized knowledge regarding the inner workings of equipment.
Beyond my knowledge of being in the stunt industry and working with that equipment.
My question is, you don't have any specialized knowledge or training on the inner workings of such equipment, right?
No training on the workings, no. But like I said, I've worked in the industry and used equipment before.
And you've never gone to school regarding the use or on the mechanics of equipment, right?
No, no official schooling for the mechanics, no.
Your Honor, we object to Ms. Sissom offering an opinion regarding the mechanics of the snap shackle and the locking carabiner, as she does not have any specialized training or knowledge regarding the mechanics of equipment herself.
And how do you differentiate between the mechanics and the non-mechanics with respect to your motion to partially disqualify, as I understand it?
Well, our witness has, or our expert has a mechanical engineering degree. It's one thing to speak generally about the snap shackle and the locking carabiner. It's another to describe, oh, it takes this amount of pressure to open and whatnot. That's the mechanics of the equipment itself, and we object to that.
Would you like to be heard?
Your Honor, we were never tendering Ms. Sissom as a mechanical engineer. Moreover, that information has already been elicited throughout the course of today's proceeding. We have no intention of having her testify as to the actual mechanics of this stunt. Rather, she is being tendered as an expert in stunt safety.
So if I understand you correctly, plaintiff's concern as it relates to the motion to partially disqualify is for a matter or subject that you didn't intend to offer this witness to testify for.
We were never tendering her in mechanics or any of that information.
Well, that makes my decision a lot easier. With that understanding, please proceed with her testimony.
Ms. Sissom, let's just cut straight to the chase. How did you start your work in this matter?
I started by going to the KWA arena with the plaintiff's expert to conduct an inspection of all the equipment used in Clark Doig's stunt.
What were the results of that inspection?
Both the plaintiff expert and I agreed that none of the equipment inspected was broken or damaged in any way, except for a disconnection from the shackle to Clark Doig's vest.
Were you able to form an opinion as to whether Ms. Cotter had dropped Mr. Doig?
Yes, both the plaintiff's expert and I agreed that Ms. Cotter had not dropped Mr. Doig.
Well, Ms. Sissom, we've heard all day today about the shackle. What was it designed for?
It was designed for use in sailing.
Was this the safest piece of equipment that KWA could have used?
It was not the safest, but it was the most practical.
What do you mean by that, the most practical?
Well, based on my review of the record, it allowed for a quicker release, which is what KWA and Mr. Doig wanted for the stunt.
You mentioned the quicker release and the practicality of this. Was this reasonable for use in this stunt?
It was reasonable given the circumstances.
What are those circumstances?
Mr. Doig was a technical and precise wrestler. He had extensive experience with stunts that required expert precision. He was in a better position to release himself from that shackle than anyone.
I want to focus on something you just mentioned there. You said that he had extensive experience with stunts requiring expert precision. Can you give the members of the jury an example of that?
Yes. Clark Doig had jumped from 20-foot steel cages down to the ground, as well as 12-foot ladders down to the ground, all without a harness, and was able to land safely.
You mentioned 12-foot ladders, 20-foot steel cages, but this was from 78 feet in the air. Does that change your opinion?
No, it does not. Mr. Doig was harnessed for this stunt, and it was a stunt that KWA and Mr. Doig had planned and practiced multiple times.
Can you tell us about the plan and the practice of this stunt?
Yes. The plan was that Mr. Doig would descend in this stunt with his arms out to the side and not move them, as to not cause the shackle to inadvertently open.
Do you know if Mr. Doig stuck to the plan when they practiced with the shackle?
Based on my review of the record, I did note that one of the practices, Mr. Doig was warned after he was seen flapping his arms and told not to move his arms and to keep them still, again, as to not inadvertently open the shackle.
Well, after he received that warning, do you know if he stuck to the plan in the next practices with the shackle?
Yes, the following two practices, Mr. Doig was able to conduct the stunt with his arms out to the side and keeping them still.
Ms. Sissom, what is your ultimate opinion in this matter?
It is my ultimate opinion that the use of the shackle within this stunt was not unreasonable, given that Mr. Doig was a technical, precise wrestler who had experience and knowledge on how to keep himself safe in releasing.
Your Honor, a moment to confer.
Certainly.
No further questions.
Cross-examination?
Ms. Sissom, you don't believe that the defendant did anything wrong on August 6th, do you?
I believe that their conduct was reasonable, yes.
Now, you have experience testifying, as you said on direct, right?
Yes.
You've testified 4 times on behalf of the defense.
Not this defense specifically, but a wrestling company, yes.
So prior to today, you've testified 4 times on behalf of defense professional wrestling companies, right?
Yes.
And today's your 5th time testifying on behalf of the defense,
Yes,
a professional wrestling company.
that's right.
And in looking at your CV, I see that you only have 1 certification, certified safety professional.
That's right.
You're not certified in wire work.
No,
You're not certified in height safety.
no, just stunt safety.
You're not even a certified stunt professional.
No, a certified safety professional.
You don't have any publications on the importance of hiring a stunt coordinator.
No,
No publications on how to jump safely without a harness.
no, I do not.
Now, on August 6th, Clark was suspended 78 feet in the air. Right?
Yes,
And he was secured by this shackle.
yes,
And this shackle, you would agree, inadvertently opened.
yes,
And in your opinion, that was because of Clark.
yes.
But it wouldn't have inadvertently opened had a locking carabiner been used.
I can't say for certain, no, but the
Okay,
shackle did inadvertently open.
well, the snap shackle has a pin that has to be pulled to release, right?
Yes,
And for this locking carabiner, it requires 10 pounds to twist
yes,
and 30 pounds to push in.
that's right.
And just to be clear, it was Cody Cotter's idea to use this shackle.
Yes,
And he didn't consult with any stunt coordinator before deciding to use this.
no,
And that's because he didn't want to pay $2,000 to hire one, right?
yes.
But he did hire you after the incident, right?
The KWA company did, yes.
And you're being paid 15 times more today than what he would have paid prior to the stunt.
Yes,
Okay. Now, this snap shackle was designed for sailboats.
it was.
You would agree with me that Clark, he was not a sailboat, right?
No, he was not.
And this snap shackle is not part of industry standards for a slow-moving descent, right?
No, I can't say that it is.
And so Mr. Clark was never told that this was designed for snap shackle, or that this was designed for sailboats.
No,
He was never told how much pressure it takes to open the snap shackle.
no,
He was never told that no stunt coordinator hadn't been consulted regarding the use of this snap shackle.
no,
But he was told by Cody Cotter that it was completely safe.
yes, as long as he remained still.
But the words completely safe came out of Cody Cotter's mouth, right?
Objection asked and answered.
Sustained.
And just to be clear for the jury, had you been contacted prior to the August 6th stunt, and the defendant said, hey, I'm going to suspend my wrestler 78 feet in the air, and he's going to be secured by this shackle, you would say go for it, because it's completely safe.
I never said that it was completely safe, just that it was reasonable and practical given the circumstances.
So I'm not asking what you said, I'm asking a hypothetical what you would say. So you would say go for it, because it's completely safe.
Objection mischaracterizes her testimony.
It's a hypothetical question, as I understand it.
No, I would not.
Overrule.
Excuse me.
Okay.
No, I would not necessarily say the words "go for it." It's completely safe, but I would let them know that it is reasonable and practical given the circumstances, as long as Mr. Doig kept his arms straight and didn't move them.
A moment to confer with co-counsel, Your Honor.
Certainly.
Nothing further.
Any redirect?
Yes, Your Honor.
Please proceed.
Ms. Sissom, you were asked a lot about the shackle that was used in this stunt on cross-examination. Why was it reasonable for KWA to entrust Mr. Doig to execute this stunt?
Because Mr. Doig had experience in keeping himself safe during stunts. He was warned multiple times not to move his arms, and given that he was a technical, precise, experienced wrestler, it was reasonable for KWA to expect he would follow those warnings.
No further questions. May this witness be excused?
Yes, please step down. Next witness.
Yes, Your Honor. At this time, the defense calls Cody Cotter to the stand. May I grab the exhibits real quick? Thank you.
Ms. Cotter, do you agree that your testimony will be the truth, nothing but the truth? So help you God.
Yes, Your Honor. And I just have my phone for timing purposes.
May I proceed?
Please.
Ms. Cotter, can you please turn and introduce yourself to the members of the jury?
Yes, good afternoon. My name is Cody Cotter.
Ms. Cotter, what's your connection to this case?
I am the owner and CEO of KWA, Klein Wrestling Alliance.
And what was your involvement in this stunt on August 6th?
I helped with the stunt and I came up with the idea.
Well, before we get to August 6th, I want the members of the jury to get to know you a little bit better. How long have you been the owner of KWA?
Since 2018.
And what made you want to get into wrestling?
Well, my dad owned a wrestling company, so when I was a teenager, I helped out. I've been in the business for a long time.
Now, we've heard all day today about KWA from other people, but I want the members of the jury to hear it from you. So tell us, what is KWA?
Sure, so Klein Wrestling Alliance, we are a professional wrestling company. We're a bit smaller. We're not like WWE, not what you see on TV. We don't do televised events, but we host weekly events and monthly premium matches.
What were KWA's finances like in the summer of 2022?
They were not great. We had been hit kind of hard by COVID.
Now, I want to talk about Clark Doig. When did KWA first hire Mr. Doig?
We hired Mr. Doig in 2019.
Was he ever re-signed?
Yes, we re-signed him 2 years later in 2021.
Now, we've heard today about the dragon character, but what was Mr. Doig's character before the dragon?
He didn't really have one.
Had KWA ever pitched Mr. Doig character ideas?
We had, we'd given him some storylines, some salacious storylines, and he declined them previously.
And to be clear for the members of the jury, whose idea was it for the dragon character?
It was Mr. Doig's idea.
Now, I want to talk about the stunt that we've heard so much about here today. And I want to start at the beginning. Whose idea was it for the stunt?
The stunt, that idea was mine.
Did Mr. Doig agree with this stunt?
He did, yes.
Now, I want to talk about the plan for the stunt. We heard today that you didn't hire a stunt coordinator for this stunt, but please tell us in your own words, why didn't you hire one?
Sure, so we had previously done a stunt like this in 2021, and I had observed and helped execute the stunt. So we had all the equipment, I had known what to do, and I didn't think we needed to spend the $2,000 to hire the stunt coordinator this time.
Was it part of the plan to have Mr. Doig flap his arms on the way down?
No, part of the plan was he would keep his arms outstretched still.
Ms. Cotter, let's talk about practice. Why did you swap out the carabiner for the shackle?
Well, the carabiner, when Mr. Doig had it in practice, it wouldn't really unlock quickly enough. He would just kind of hover over the mat. So he needed something that would unlock and release quicker.
Where did you get the shackle?
On Amazon.
And would you recognize that Amazon ad if I were to show it to you here today?
I would, yes.
Your Honor, approaching the witness and publishing to the members of the jury what is already in evidence as Exhibit 7. Would Your Honor like... I'm sorry?
I have a picture. I have it. I don't need it. Yep.
Yes, Your Honor. There we go. Now, Ms. Cotter, directing your attention to the phrase sailing hardware, did that concern you at all?
No, it didn't.
Why did it not concern you?
Because this is what came up when I Googled how to lower a person into an arena.
And what specifically about the weight of this shackle made you feel comfortable in using it?
Well, it says it can hold up to 880 pounds.
For the record, publishing what is already in evidence as Exhibit 6A. Ms. Cotter, is this the shackle you bought?
The top part is, yes.
Well, directing your attention to that advertisement, I don't see anything specifically about a green rope. Can you tell us what this is?
Yes, so it does say in the advertisement that a lanyard, cord, or rope can be attached to the shackle, so I actually found that rope in my home.
And what was the first thing you did once you had the shackle and rope?
So once I attached them together, then we would attach the rope actually to the back of Mr. Doig's vest.
And how would that be attached?
We would tape it on.
Now, when you arrived to the arena on August 6th, what was the first thing that you did with the shackle?
I tested actually a 250-pound bag of sand.
And why'd you use a 250-pound bag of sand to test this shackle?
I just wanted to make sure that it was secure and that it would hold that kind of weight.
And did it?
It did, yes. I actually did it, and then I repeated it 3 times.
Now, when Mr. Doig arrived to the arena, were you able to show him the shackle and the rope?
I was.
What, if anything, did you offer to do with the shackle and the rope?
I said I could try it out first. I could get the harness on and lower myself the way that Mr. Doig would be doing it in the stunt.
How did Mr. Doig respond to this offer?
He declined. He said he just wanted to try it.
Before we get to those practice runs, what, if any, instructions were given to Mr. Doig about the shackle and rope?
Well, I said that it was completely safe, that he just had to stay still.
Now, moving to those practice runs, we heard that 4 practice runs were conducted today. What, if anything, in those practice runs, what, if any, instructions were given during those 4 practice runs?
Counsel, are you talking about the practice runs on the day of the event or the earlier day?
Your Honor, I can clarify.
Please.
Ms. Cotter, on the day of the event on August 6th of 2022, in those 4 practice runs, what, if any, additional instruction was given to Mr. Doig about this shackle and rope?
Yeah, so on this day, the day of the stunt, when we were practicing, I noticed Mr. Doig would start to put his hands out and then flap. He said he was flapping like a dragon, and I said to stay still, keep still, because that was how he needed to do the stunt.
Ms. Cotter, what specifically did you tell Mr. Doig about not moving his arms?
I said, don't move your arms, because this is a matter of life or death. It's not safe, because I knew that the snap could open.
Now, we know that there were only 4 practice runs conducted with this shackle and this rope. Can you tell us, why is that the case?
Well, I offered to do more, but Mr. Doig, he just wanted to get something to eat. He seemed cranky, so we moved on. He was ready.
Now, moving to later that night during the stunt, as you lowered Mr. Doig down, what, if anything, did you see?
During the actual stunt, as I started to lower him, I noticed that he moved his arms. It was like 1 or 2 quick movements.
Moment to confer, Your Honor.
Certainly.
No further questions, Your Honor.
Are there any other witnesses?
Cross-examination, Your Honor?
I'm sorry, I neglected to give you that opportunity. Please proceed.
Ms. Potter, as you just said, it was your idea to do the August 6th stunt.
Yes,
It was your idea to use the snap shackle.
it was, yes.
It was your idea to attach the green cord.
Yes,
It was your idea to not hire a stunt coordinator.
that's correct.
Let's talk about why you made these decisions. KWA had a reputation for pushing the envelope.
Objection, Your Honor. Improper character.
Sustained.
Your Honor, maybe heard.
Sure.
Rule 404, which encompasses character evidence, says a person's character may not be brought up. When we compare this to Rule 406, that rule says a person or a company. Here I'm asking about KWA, which is a company and their traits.
Having heard your response, my ruling remains the same. I've sustained this objection.
During the summer of 2022, KWA was not doing well financially.
Not great. Yeah, that's correct.
This was after COVID, right?
Correct. We had been hit a little hard by COVID.
You weren't having matches during that time period.
That's correct.
And during the summer 2022, ticket sales were down.
That's correct.
You were looking for ways to increase interest.
Yes.
You presented Clark Dwight with the idea of an August 6th stunt.
Yes.
It was based on a previous stunt from 2021.
That's correct.
But in this previous stunt, you hired a stunt coordinator.
In 2021, yes.
That stunt coordinator provided the equipment.
Yes.
They oversaw the stunt itself.
Yes.
And they did the training for the wrestler, correct?
She did, yes.
In 2022, you did not hire a stunt coordinator.
We did not, no.
You said you didn't see the point
That's correct.
because it would cost $2,000.
That's correct, and we had the equipment.
That's right, you had the equipment from 2021.
Yes,
And on August 2nd, you practiced with the equipment from 2021.
we did.
But you claimed that those practices looked horrible.
Yeah, it was tough with Mr. Doig just kind of awkwardly hovering.
You claimed that it took 15 seconds to open the Snapchat.
That's correct.
When Clark was doing this stunt, you say he looked awkward.
Yes,
He was the dragon, right?
he was.
That gimmick was supposed to look awkward.
That was part of his role. It was goofy.
But regardless, you wanted to find something else.
Yes, and he was frustrated with it as well.
You went to Google
I did.
and you Googled lock I can use to lower someone.
Yes,
And you ended up on an Amazon page.
correct.
May the record reflect I have what is already in evidence as Exhibit 7. Permission to republish to the jury, Your Honor?
Certainly.
I believe they already have copies.
Please proceed.
I have a copy as well.
Oh, perfect. Ms. Conner, on the biggest font on this entire page, it says, quick release saline hardware.
Yes.
Nowhere does it say that this is stunt equipment.
No, it does not.
Nowhere does it say that this can be used to lower a person.
No, it does not.
At this point, you still did not contact a stunt coordinator.
I didn't, no.
Not Sarah Williams,
No,
not River Sukesh,
no,
not Cal Sisson.
no.
You decided to buy the Snapchat,
I did, yes.
and you presented it to Clark.
I did.
When you presented it to Clark, you told him it was completely safe.
I did say that, yes.
And then you started practicing.
Yes,
And you noticed that in one of the practices, he moved his arms.
he did.
You told him that that was unsafe,
I did,
to not do that.
yes.
On the Tuesday practices, you had also noticed that he was moving his arms,
Yes,
he was touching his wrists,
yes.
adjusting his neck,
I did see that, yes.
and adjusting the vest.
Yes,
You then practiced more times with Mr. Doig.
we did.
But at no point did you tell him that this snap shackle is a piece of saline hardware.
No,
At no point did you tell him that you had not consulted the stunt coordinator about this snap shackle.
no,
At no point did you tell him that it only takes 9 pounds of pressure to open.
no,
At no point did you tell him that in order to open it, you only need to move the pin 1/4 of an inch.
no.
You decided to go forward with this stunt after the practices.
Yes, we both did.
And on August 6th, you were up there on the catwalk, right?
I was,
You were going to be the person lowering Clark Doig.
yes.
Let's be clear, you're not a stunt coordinator.
I'm not, no, that's not my title.
You began to lower Mr. Doig,
I did,
and almost immediately, he was free falling,
yes,
and he fell to his death.
he did.
No further questions, Your Honor.
Any redirect?
Yes, Your Honor.
Please proceed.
Ms. Cotter, we just heard a lot about your actions in this case, but to be clear for the members of this jury, who agreed with the plan for this stunt?
Mr. Doig did.
And who agreed to practice this stunt?
Mr. Doig.
No further questions, Your Honor. May this witness return to counsel table?
Yes, please.
And Your Honor, permission to approach the witness as well as the members of the jury to retrieve the exhibits.
By all means. Are there any other witnesses?
No, Your Honor. At this time, the defense rests.
Okay. Do you need time to prepare? Do you have any rebuttal witnesses?
No, Your Honor, no rebuttal witnesses.
Okay. Are you
Your-
prepared to close? I'm sorry.
Your Honor, prior to closing, the defense does have a motion to be heard outside the presence of the members of the jury.
Is it a Rule 59 motion?
Yes, Your Honor.
Okay, please proceed.
Your Honor, at this time, the defense renews its motion for a judgment as a matter of law. Even still viewing the evidence in a light most favorable to the plaintiff, they have failed to put forth sufficient evidence for which a reasonable jury could find that they have met their burden. In addition to our arguments raised at pretrial, we have now heard expert testimony from Ms. Sissom that this was a reasonable risk for KWA and Mr. Doig to take using this shackle, given Mr. Doig's experience as a precision and technical wrestler. Therefore, we ask the court to grant our motion.
Would you like to be heard?
Yes, Your Honor. The issues that opposing counsel is referring to are issues of weight for the jury to determine. We have provided evidence of the negligence of the defendant, and the jury should have the right to reach a verdict as to that.
The motion for a Rule 59 dismissal of the complaint is denied. We should proceed with closing arguments.
Yes, Your Honor.
Prior to closing arguments, may we request a brief 5-minute recess?
Do we have time for that?
Yes.
Okay, yes, please.
And we may also request a time check from the bailiff.
Yes, you actually each have 24 minutes.
Are you going to be sharing the closings, or will one counsel be closing?
One counsel will be
Each
closing.
side, okay. And with respect to the defense's closing, it might be helpful to the jury if you can delineate your positions with respect to, one, whether or not plaintiff made out his negligence claim, two, your assumption of risk defense, and three, your contributory negligent defense. If that's not too much of a burden on whomever is closing, I think it would be easier for the jury to understand which part of your case you're arguing. Please, thank you. 5 minutes then, we'll proceed.
Yes, Your Honor.
I'm an employment litigator, so these issues are not issues that I've really seen during the course of my career. Were you one of the persons who were responsible for drafting this case? I wonder why there isn't a workers' comp bar, because it seems to me that even though plaintiff was an independent contractor, not an employee, there's this borrowed servant doctrine. And it would seem to me that his recourse, or the decedent's recourse, would be through the workers' comp bar, but I could be wrong. That was just my first reaction. I'll ask Phil, but yeah. Oh, okay. Right, yeah. I have seats in the same section as Tom Klein does for the Sixers, but he's on the first row and I'm on the 18th row, so, yeah. It's a difference between, actually, people sometimes confuse me for him. I used to have really long hair, and yeah, right. But there's a difference between, obviously, the plaintiff's side and the defense side. Yeah, I am. I started out as a labor lawyer, but I've kind of morphed into an employment litigator, yeah. But this is fun. I would do this again, yeah. We had moot court when I was in law school, but we didn't have anything like this. Right. Counsel, are you ready to close? Are we missing a juror? Okay. Yeah. I should take a better count of that, yes. There she is.
Yes, turned on.
Counsel, are you ready to close? Court is ready, Your Honor. We are ready. Is the jury ready to hear closing arguments?
A brief moment to set the ball up.
Yes, certainly.
May I proceed, Your Honor?
Please, thank you.
4 cut corners and a dead man in the ring. The defendant took shortcuts for a high-risk, dangerous stunt, which resulted in Clark Doig dropping 78 feet to his death. But before we get into the evidence and how we prove the defendant's negligence, I want to take a moment to acknowledge our burden of proof. Our burden is the preponderance of the evidence, which simply means more likely than not. Our burden is met if the scales move ever so slightly or an ounce over 50% in our favor. That meets the burden. In reviewing the evidence, it is clear that the defendant was negligent by cutting 4 corners, which resulted in Clark Doig being suspended in the air 78 feet, secured only by 1/4 of an inch of a pin that took 9 pounds of pressure to release. No reasonable wrestling company would have done that, and that's what we proved today. But let's start by going over some facts that both sides agree on. It was Cody Cotter's idea to do the August 6th stunt. It was her idea to use the snap shackle on this stunt. It was her idea to attach the green cord, and it was her idea to not hire a stunt coordinator. Lastly, both sides agreed that the snap shackle in this case likely inadvertently opened. Much of the disagreement stems from the 2 experts. We brought in River Sukesh, who for the last 8 years has worked as the chief safety officer for Walt Disney Studios. His job is to make sure that stunts in films like Star Wars and the Marvel superhero movies are done safely. On the other hand, the defense brought Hal Sissom, who is a wrestling consultant, who every time they have testified in court has been in support of defendant wrestling companies. What we saw today is that the defense expert witness is just an extension of the defendant wrestling company. So of course they're going to take this stand and say that they did nothing wrong. That's because she wants to keep getting hired by them. That's because of her own bias. These experts, they're not the same. The defense expert's opinion, they don't stand to reason. Our expert, River Sukesh, his opinions stand to reason and they make sense. Mr. Sukesh explained the 4 corners the defendant cut and how these corners resulted in Clark Doig laying dead in the ring. The first corner is that the snap shackle should not have been used for this stunt. The way that Cody Cotter found this snap shackle was by doing the bare minimum she could. She Googled it. She's looking for something to make sure Clark's not in danger, and she Googles it. She does what someone does when they're trying to find a place to eat, or when you pull your phone out to win an argument with a friend about how many touchdowns Jalen Hurts had last season. She Googles it and ends up on an Amazon page where in the biggest font in the entire page, it says, quick release sailing hardware. And instead of doing the reasonable thing and reaching out to a stunt coordinator, to Sarah Williams or Cal Sissom or anyone qualified to plan this stuff, the defendant clicks behind me. With this snap shackle, Clark quickly released himself by just pulling this pin. It's like the pin of a grenade, except instead of exploding, when you pull this pin, It releases whatever it's holding, quickly and suddenly. And on August 6th, it did what it was supposed to do, because Clark dropped those 78 feet really fast. Corner 2. The defendant failed to properly instruct Clark Doig as to what to do. All the defendant said was to not move your arms. But when the only thing securing you from dropping 78 feet is a quarter of an inch, being told not to move is not enough. Corner 3. Clark should not have had the ability to release himself. We heard from our experts that having the ability to release yourself is dangerous. When wrestlers are doing stunts, they're responsible for a whole lot of things. Adding to this, being able to release themselves add to the danger. He should not have been able to have that cord, especially with the snap shackle that may inadvertently open. But when we're thinking about the defendant's logic for switching the equipment, they claim that it took 15 seconds to open this snap shackle, this locking carabiner, and that looked awkward. When we consider what Clark's gimmick was, wasn't that the point? He was supposed to be a joke. He was supposed to be awkward. He was supposed to be clumsy. Think about it. The defendant could have been playing some goofy music in the stadium while he struggled for 15 seconds, only to finally release himself and land face first in the middle of the ring. If they wanted a comedic entrance, this works. But instead, they chose to go with the snap shackle because the defendant believed that it was safe. Which brings us to our last corner. The defendant modified a stunt from 2021 without consulting a stunt coordinator. Let's be clear, Cody Cotter is not a stunt coordinator. They are not qualified to safely plan and execute stunts. That's why in 2021, when they did a similar stunt, they brought in Sarah Williams, who provided the equipment, the training, and executed that stunt. But in 2022, they did not bring in a stunt coordinator, despite the fact that these were different stunts, and in this stunt, Clark was going to be released mid-air. The equipment from 2021 was not appropriate for the 2022 stunt. They should have had a stunt coordinator. Now, the defense is trying to say that they didn't need an expert to determine if this was reasonable or not. But the very fact that Cal System came and took this stand undermines that point. It's either you need an expert or you don't. And if you didn't need an expert, Cody Cotter, when she was testifying, she could have tried to convince you herself that what they did was reasonable. But instead, they brought in Cal System to give an opinion, because both the defendant and Cal System knows that's what should have been done before the August 6th stunt. Let's also remember what happened when Ms. Lopez was asking their expert questions. She asked her if she would agree with the defendant that this stunt was completely safe. And their witness said that she wouldn't have said it was completely safe. That's something that the defendant could have learned if they had reached out to a stunt coordinator before the August 6th stunt. Instead, they reached out to them and had them testify here today when it was too late, when Clark's body was already dead in that ring. What the defendant did was not reasonable. In a few moments, you're going to go back to the jury deliberation room. And when you do, you're going to see this verdict form. It's going to ask you 3 questions. And the first one is, did the plaintiff prove by preponderance of the evidence that the defendant acted negligently? And did that negligence result in Clark's death? And that essentially means, did the defendant act reasonably? And in today's trial, we actually saw what a reasonable wrestling company would have done. No one disputes that the 2021 stunt was reasonable. The defendant knew what they had to do in 2022 to ensure safety. They had done it just 1 year prior. But instead of doing what they knew to be safe, they cut corners, which resulted in a dead body in the middle of that ring. For this reason, we are confident that for this question, you're going to answer yes. Question 2 asked, did the defense prove that Clark assumed the risk? The reason this question's on here is because the defendant's actions were so clearly unreasonable that they're trying to shift whatever blame they can and say that it was Clark's fault. But let's remember what he was told before he ever practiced with the snap shackle. the defendant told him it was completely safe. Members of the jury, if something's completely safe, it means there are no risks. Today, they're trying to backtrack and say that Clark should have known the risks. According to the defendant, there were none. They can't have it both ways. Their argument makes no sense. Just like their actions on August 6th, this is unreasonable. That's why for this question, you should answer no, because Clark Doig could not appreciate a risk he was unaware of. And the only thing this defendant told him was that this stunt was completely safe. Based on the evidence, question 3 is the last one you're going to have to answer. This question asks, did the defense prove that Clark himself was negligent and that that negligence resulted in his injuries? Remember, it's the defendant who cut the corners in this case. It's the defendant who put Clark in danger. You heard the testimony of Cody Cotter when she took this stand. She said that she noticed on August 2nd that Clark was moving around, adjusting the vest, and doing all these other movements. And yet she still allowed him to go through with this stunt, even though she was aware that that snatch shackle could open. And according to her, that was completely safe. Clark did nothing wrong in this case, except for trusting this defendant. For that reason, we're confident that for this last question, you're going to answer no. And with that, you have a verdict. You have the verdict that's supported by the evidence, finding the defendant liable for the death of Clark Doig, finding justice for Clark. In wrestling, the matches may be fake, but the risks are real. The danger is real, and the consequences for Clark were deadly. You can't cut corners in the ring. Based on how many shortcuts this defendant took, they may as well have just pushed him off that catwalk. The result will be the same. One dead body in the middle of the ring. Find this defendant liable.
Thank you, very nice closing. Ms. Ballard?
Yes, just a moment, Your Honor. Yes, thank you. Thank you, Mr. Yost. May I proceed?
Yes, please.
They were in it together. Members of the jury, the plaintiff just got up here and told you we can't have it both ways. And we agree. At no point today have we ever denied this stunt was risky. At no point today have we ever denied KWA wanted this stunt to be successful. But so did Clark Doig. If there was anyone who could do the dragon stunt, it was Clark Doig. He was KWA's most experienced, most senior technical wrestler. That's why KWA pitched him this stunt. That's why he agreed to do it. He agreed to do this stunt because he knew this was his opportunity to become Clark the Dragon Doig. They were in it together. Members of the jury, what happened to Mr. Doig is tragic. But the plaintiff doesn't get to stand up here, point the finger only at KWA, and tell you this case is about 4 cut corners KWA took. Because that fails to recognize the part that Clark Doig had in the planning, preparation, and execution of this stunt. Because just like my co-counsel, Mr. Yost told you at the very start of this trial, this case is about KWA taking a risk. But it's also about Clark Doig assuming that risk? Because they were in this together. That's why this case comes down to two simple facts. They planned, they practiced. Together, they planned the stunt. Together, they practiced with the shackle. And we're going to talk about both of those things, but first let's clear some things up. Because the plaintiff has tried to say all day today that somehow this was some way that KWA would make money, and that Mr. Doig was pressured into doing this stunt. He was forced into it. Members of the jury, that's just not the case. Think about it. The plaintiff's very own witness took this stand, Sid Gaskins, and told you, when Mr. Doig was hired, he didn't have a character. He was a mid-card wrestler, someone the fans weren't always wanting to watch. And KWA hired him anyway. In fact, KWA and Mr. Doig worked together to come up with new and exciting ideas. Ideas that Mr. Doig was free to and ultimately did turn down. But KWA didn't punish him, they didn't fire him, they didn't let him go. No, they kept working together to come up with the next idea. And as far as this being something that KWA was doing for profits, members of the jury, let's be crystal clear. This was not the headlining event on August 6th. This was one stunt in the middle of one match. There was no guarantee for KWA, no guarantee that this would turn a profit. There was no guarantee that this would bring in more fans. But there was a guarantee for someone. There was a guarantee for Clark Doig that he could take his character to the next level. That's what brings us to the plan of the dragon descending down from 78 feet into the ring. Members of the jury, we have never disputed this stunt was risky. But Mr. Doig assumed that risk. And to be honest, that makes sense. It makes sense that KWA and Clark Doig would take that risk together because this was their most experienced wrestler. This was their most senior technical wrestler. This wasn't KWA handing that shackle to a rookie on their first day and saying, good luck. No, this was a wrestler who had experience jumping from 12-foot ladders and 16-foot steel cages. He knew how to control his body, and he knew how to perform stunts safely. And yes, in the past, we agree. KWA did use a stunt coordinator, and we did use 2 interlocking carabiners. You heard from the plaintiff's very own expert, Mr. Sukesh, that that's exactly how this stunt started. By using that industry standard carabiner, the plaintiff was very excited to show you all day today. But you know what Mr. Doig thought of that carabiner. Because members of the jury, you heard his words for yourself. It feels so lame. Just dangling here, trying to unlock this thing. He was embarrassed. His big stunt, it wasn't working the way he wanted it to. So what did Cody Cotter do? She bought a shackle. But again, she didn't just slap it onto his vest and say, good luck, I hope it works out. She tested it with a sandbag. And there were 4 successful practices with that sandbag. And then Mr. Doig arrived to the arena. And you know what Miss Cotter offered to do. She offered to put on that vest, go up 78 feet in the air, rappel down into the ring, and release herself, just to show him how that shackle worked. But that didn't happen. It didn't happen because Mr. Doig said, hey, it's okay. I'd rather test this one out for myself. But before he could ever put his hands on that shackle, Miss Cotter told him, don't move your arms. Be still. And that's what brings us to the fact that they practiced with the shackle. all day today, the plaintiff has brought you this shackle. They've shown you the shackle, they've shown you the rope, they've told you how dangerous it was, how unreasonable it was that anybody could ever use this for a stunt. Members of the jury, do you know who saw this shackle, who saw this rope, and who felt the release not once, not twice, not 3 times, but 4 times? Clark Doig used this shackle. 4 times Clark Doig felt that release. 4 opportunities for him to say, whoa, I'm not doing that. That's too dangerous. We need to use the carabiner instead. 4 times he never said that, members of the jury. Instead, you know what he said. He said, wow, this shackle is so much easier to open than the other one. And the plaintiff has made a big deal today about the warnings that Mr. Doig received. Let's be clear. When Cody Cotter saw Mr. Doig flap his arms on that second practice run, she ran down to the ring. Stop! Don't do that thing with your arms. It's not safe. It's a matter of life and death. And then they practiced again, a 3rd time. And Mr. Doig stuck to the plan. He didn't flap his arms. The pin didn't release early. And then they practiced again a 4th time. And Mr. Doig stuck to the plan. He didn't flap his arms. The pin didn't release early. So after 4 successful practices with that shackle, it was reasonable for KWA to trust their most experienced, senior, technical wrestler to follow the most basic of instructions, to follow the plan. And yes, you heard all of that today from our witness, Cody Cotter. But members of the jury, don't feel like you just have to take Ms. Cotter's word for it, because you heard all of that from someone else. Sid Gaskins. The plaintiff's very own witness confirmed all of this for you today. Members of the jury, Sid Gaskins took that stand today and told you Cody Cotter gave Mr. Doig a lecture about not moving his arms. Not only that, but we were keeping track, members of the jury. 4 times today, while Sid Gaskins was on that stand, she was forced to admit Clark Doig and KWA agreed to do the dragon stunt. They agreed to practice with the carabiner. They agreed to practice with the shackle when that carabiner wasn't working. And they agreed that Mr. Doig would release himself. Now, in just a moment, His Honor is going to give you a verdict form. It's going to look something like this. And I know there's a lot of text, it's far away, but let's just walk through it. When you get to question 1, that's asking you whether KWA was negligent. And members of the jury, go ahead and mark yes. Because as we have told you all day today, this stunt was risky. We agree. It was reasonable, but it was risky. And we accept that responsibility. But just because you mark yes to question 1, that does not mean your job here is done. Because that brings you to question 2. Whether Clark Doig assumed the risk. And for every single reason we have talked about today, the answer to that question is yes. But members of the jury, there is just one more reason. Clark Doig moved his arms. No one today could tell you exactly why. They couldn't tell you exactly how. And to be honest, that doesn't matter. It doesn't matter if he was trying to keep himself balanced. It doesn't matter if he was fidgeting with his costume. It doesn't matter if he was trying to make the dragon fly. Why doesn't it matter? Members of the jury, it doesn't matter because Clark Doig assumed the risk of this stunt the moment he put on that vest. Went up 78 feet in the air, the moment he agreed to use that quick release shackle. So when you mark yes, question 2, that Clark Doig assumed the risk, your job here is done. Go ahead, give the verdict form to his honor. You can go home. Because KWA did take a risk. But Clark Doig assumed that risk because they were in this together. Thank you.
You didn't reserve time for, to make another argument in response to defense's argument. Do you want to be heard on something?
Yes, Your Honor, on the rebuttal for this.
Okay, please.
May I ask how much time we have left for rebuttal? Opposing counsel just came up here and told you that Clark Doig assumed the risk. But remember what he was told before he agreed to do this stunt. He was told it was completely safe. Now, let's remember what he didn't know when he was told it was completely safe and agreed to do this stunt. He didn't know that the snap shackle was a piece of sailing. He didn't know that a stunt coordinator had not been consulted about this. He didn't know that it only takes 9 pounds of pressure to open that snap shackle. And he didn't know that you only have to move the pin 1/4 of an inch. They want to say that Clark and KWA were together on this. But it was Cody Potter who looked up the snap shackle. Clark wasn't there. That was her decision, and she did that. Clark Doig was not together with them when they decided not to bring in a stunt coordinator. Now, I noticed something during this case. When opposing counsel was just talking, they said that Clark moved his arms. And while we do have some testimony that he was moving his arms as he was falling, that comes from the defendant. And let's remember the stipulation in this case. The first 20 feet of that catwalk, no one can see that outside of the people on that catwalk, outside of the defendant. So of course they're going to try to say that Clark was doing something, but that's the only person who saw anything. And of course she's going to try to shift whatever blame they can. No one else saw it. We have no credible evidence that it happened. Additionally, they want to harp on this idea that that Cody Potter warned him that this was a life and death situation. But this is another area where the defendant's credibility should be in question. Sid Gaskin took this stand and said that all she heard was, don't move your arms, that's not safe. A far cry from the defendant's strength. Clark Doig cannot assume a risk that he didn't appreciate. And in this case, what he appreciated, what he trusted, was that this was completely safe. Thank you.
Ms. Ballard, is there a last word that you'd like to provide?
No, thank you, Your Honor.
Thank you. Very well argued, counsel, for both sides. I think we're finished. Okay. Well, thank you for coming to Philadelphia and making these arguments. Okay, perfect. I've already hit submit. I've already hit my submit. I don't know whether the other judges have. Do you need the numbers of the teams? Do you have those? Okay. Now, people who tried their cases today, are they off on Saturday, or might they have another? It goes again tomorrow. And then I'm here on Sunday, and there will be 4 teams left on Sunday.